in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial, we pay the price.
Hey, folks, and welcome to a day of frustration. I just read the first paragraph in one of the state's replies. Now, they filed replies up until midnight Friday. That is why we never saw that many. But I was under the impression that the judge said before end of business on Friday, not the end of Friday. So that will be really, really interesting to see tomorrow when the hearings start. But first of all, after a few weeks, everybody say hello to Gigi, my first and best moderator. Good to have you back. Good to have you back. I hope you have a great time in that new place of yours. I hope everything went okay. Good to have you back. Good to have you back. I missed you. Everybody missed you. Everybody missed you. Who else is here? Sagalina, so Diogo. And Denise, Christine is here, Nurse Shells. And there's a bunch of people here. There's a bunch of people. I am kind of competing against people who already go through this. I have no issue with that whatsoever because I have work. I saw it happening, and I couldn't go live when it happened, when the files dropped. So you have to wait until I got home. And now I am. Diogo also bought a house in Wisconsin, moving there in December of this year. Always have your phone on. Because people get convicted of murder for not having their phone on. This is your first house. That is a glorious feeling. Now, I'm very lucky with this because I got my first, not house, but my first apartment, my own, in 1991. I bought it just before the 1991 crash. So yeah, that wasn't fun. But at least I had a home to live in. Oh, you live in Romania? Hello. Hello Romania. I don't speak Romanian. I barely read Romanian, but I do follow the local news about the Andrew Tate case. That is quite amusing. I try to read it in Romanian first before I have to translate it. So I don't. Oh, you're in a temp place now. Well, temp place, if you're going towards something better, is good. It's good. Politicking with Mel is here as well. Simply Taught. Erin Olivia. All right. Let's get our blood pressure up. I'm going out on the deep end here, on the rough end. We will see if YouTube decides I'm allowed to, if they close down my stream or not, because this one, folks, this one is maddening. It's infuriating. The gall. Let's go. Let's rant about it. Let's see here. Dun, 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 dun. Dun, dun, dun. Let's bring that up here on that screen so I can see everything that's going on meanwhile. In the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams et al. Motion to compel defendant's compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed. First of all, that's a paragraph. Again, Adrienne Love cannot write motions. She is mentally unable to write a proper motion. Just listen to the phrasing here. Motion to compel defendant's compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed. That is a rough sentence to say. And when it's rough to say, means it's poorly written. Now, what does it mean? Well, the prosecution have the audacity, the gall, to have the judge punish the defense for not disclosing evidence in a timely manner. This prosecution, who we have seen since end of November of last year going forward, time and time again, refusing to disclose what evidence they plan to use with which witness. And now they have the audacity to ask the judge to punish the defense because they claim any evidence intentionally withheld and not timely disclosed. It's not their case yet. It is not the defense case yet. And if they mean the people on the stand, well, that's Woody. How can they disclose anything they plan to use against him when he's not done on the stand, when the prosecution isn't done? Now, what they actually mean here in this little paragraph is for the judge to exclude the transcript from the ex parte meeting, because they know how bad it is. They know exactly how bad this is for the prosecution. Remember, folks, most people who watches this trial have not seen the transcript yet. Because even though we have some big channels covering this, you still have the law and crime audience who only watches the law and crime channel and nothing else. They have not seen this yet. And those who usually are very pro-prosecution, they aren't right now. And this will hammer. This will hammer. This will make headlines once it's up again. And with Woody on the stand, the prosecution knows they are effed if Woody gets asked questions about the ex parte meeting because they know he will talk to the defense. He might even make up stuff. And in this, normally, I don't like when witnesses make stuff up. I might do an exception in this case, just to watch Love, Hilton, Willis, and the other people on the prosecution side jump up. Objection. That way. But this motion is infuriating. So let's continue. Pursuant to OCGA 17-16-4, the state of Georgia moves this honorable court to compel each defendant currently on trial to comply with the reciprocal discovery demands imposed on defendants by OCGA 17-16-4. Again. Again. Now they realize they do not have Judge Glanville on the stand anymore. They have a judge who actually might go by the rules. The actual rules, not the ones that Miss Love BS about in court. The actual rules. Further, the state moves this honorable court to exclude any evidence in the possession of either defendant that has not been provided to the state at the time of this filing. So they're in the middle of the prosecution's case in chief. They are in the middle of having Woody on the stand. And they are so desperate to not have Woody being cross-examined on evidence they know are out there. They know is in the possession of the defense. That they want a clear-cut line for Friday. And in support of this motion, the state shows this honorable court as follows. Factual background. Defendants were indicted on the instant case on August 5th, 2022. The state began presentation of its case in chief on November 27th. More than 12 months prior to the beginning of the state's case in chief, each defendant opted into discovery under OCGA 24/16/4. The state provided its first round of discovery to defendants on July 11th, 2022, and the state has continued to comply with its ongoing discovery obligations. What a load of horse manure in that alone. Even Judge Glanville, when he still was judge, had to put his foot down several times to tell the prosecution, you have to provide the evidence to the defense before you try to admit it in court. Now, Judge Glanville still tried to blame it on the defense, but even Judge Glanville, on a few occasions, not even he could hold the back of the prosecution. During the course of this trial, defendant Williams has repeatedly withheld from the state evidence in his possession even before the start of the trial, until after the state began examining the witness through whom defendant Williams sought to and was allowed to introduce. The fuck? Oh, Jesus. Defendant Williams withheld an audio recording of an interview with state witness Adrian Bean for 406 days, till hours before his cross-examination of said witness. Folks, that audio recording with the interview of Adrian Bean was in discovery. They are just mad that the defense found it. Alexei muted asks, why is this a footnote? I don't know. Miss Love can't write motions. This footnote is an argument or an exhibit or an evidence, an example of the argument in the previous paragraph, which easily could have been in that paragraph. And why does she do this? Because she can't write motions. It is infuriatingly bad. Motion to compel to comply with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed to the state. See here? That's a headline that she forgot to emphasize, or whatever it's called. It should have been one of these. Instead, she forgot. She hasn't even proofread. I'm quite certain the reason why Miss Love is writing all this is because when she asks the others, they don't want a part of it because they know they are on the actual line of misconduct. I believe, in my opinion, they are way over that line. Way over. But the courts generally have a higher bar on that than I do. But I don't think the rest of the prosecution's team wants to be a part of it. That is why Fani Willis and Adrian Love is writing all of this crap. At the first non-violation of defendants Williams' discovery obligations, the state moved the court to compel the defendants, and particularly defendant Williams, to comply with OCGA 24-16-4. In the alternative, the state moved the court to exclude any evidence withheld from the state in violation of the statute. Defendant Williams argued that he has no duty to disclose any evidence to the state unless and until he begins a case in chief or rebuttal. The trial court then denied the state's motion after noting that it appeared to the court defendant had no obligation to provide evidence to the state until after the conclusion of the state's case in chief. Yeah, listen, this was the ruling of Judge Glanville. Not even he could support the prosecution here. That's what I said. I should have kept reading. So, wait a minute. Motion to compel defendant's compliance with, but here they have it. They already have a ruling. So the motion here should not be against the defense to comply. It should be towards for Judge Whittaker to reconsider a ruling by Judge Glanville. Not even that Ms. Love gets right. Not even that Ms. Love gets right. Legal analysis, analysis. A defendant's refusal to timely disclose evidence in his possession, custody, or control, which he intends to introduce to both impeach a witness and to prove his innocence, constitutes a violation of defendant's reciprocal discovery obligations that warrants exclusion of the evidence at trial. Let's see here. OCGA 24-4-16 requires that a defendant within 10 days of timely compliance by the prosecution attorney, but no later than 5 days prior to trial, or as otherwise ordered by the court. Here is the otherwise, what was the language? Or as otherwise ordered by the court. Here is that one. The trial court then denied the state's motion after noting it appeared to the court defendant had no obligation to provide evidence to the state until after the conclusion of the state's case in chief. Again, Prosecutor Love didn't want to write a motion to reconsider a prior ruling because that would open the barn doors for the defense. Instead, she tries to act like it's a completely new thing. Jeez. Shall permit the prosecuting attorney at the time agreed to by the parties or as ordered by the court to inspect and copy or photographs. Again here. At agreed to by time agreed to by the parties or as ordered by the court. Hey, Cat. Cat's here. Hey, thank you so much. Gifted 5 memberships. Thank you so much. Went to Gwendolyn, Eve, Concrete Rose, Robert Libby, Ron Barnes. Congratulations. You now have all access you need to my members-only content. Love doesn't pay attention to or language. No. I mean, she is. I don't know how long we were here. This should be a motion to Judge Whittaker to reconsider a prior ruling. Instead, she writes this as this other kind of garbage motion. It is infuriatingly bad. Thank you, Kat. Thank you. Wait a minute. Or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, custody, or control of the defendant, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial. But she already moved past. Here is the headline for the next chapter. What's going on? Miss Love really can't write motions. OCGA 17-16-4B1. Case in chief includes evidence offered by a defendant both as impeachment evidence and as substantive evidence of innocence. U.S. v. Young. Affirming the district court curative action against the defense in a criminal case for failing to turn over a tape of a government's witness, which the defense sought to introduce during cross-examination as both impeachment evidence and as substantive evidence of innocence. U.S. v. Waddell. Denying government's motion for reciprocal discovery of tapes based on defense's representation that he did not have them, but admonishing, quote, that if he's lying about possession or control of the recordings and later tries to introduce them during this case in chief, that evidence will be subject to exclusion. The defendant has an underlying duty to disclose prior to trial and an ongoing duty to timely disclose any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. That is not the wording in the damn rules. That is not the wording. This is so bad. This is so insanely bad. Jesus Christ, Miss Love. How did you finish law school? How can you have been a prosecutor for this long? But my previous theory, up until now, she have had other people write her motions and then she signs it. Now she can't get them to do it. Now she has to write them herself. And all of a sudden, it is obvious, to me at least, she has no idea how to write a motion. She has no idea. And here she repeats herself. Defendant Williams has repeatedly refused to comply with his reciprocal discovery obligations. Any further refusal by Defendant Williams to timely disclose evidence warrant the extreme remedy of the exclusion of the evidence at trial. She just repeats herself. But let's go back and read this thing here. The trial court then denied the state's motion after noting that it appeared to the court defendant had no obligation to provide evidence to the state until after the conclusion of the state's case in chief. I do believe this is not an accurate representation of Judge Glanville's ruling. Now, I don't remember the exact ruling he made, but as per usual, he punted something forward, if I remember correctly. Let's go back to the garbage and she repeats herself. She writes that there. She wrote that third time she writes that piece of garbage. The state therefore moves this honorable court to compel each defendant in this case to immediately comply with the reciprocal discovery demands of 17-16-4 and disclose to the state any evidence in the defendant's possession, custody, or control that reasonably may be offered both to impeach a witness and to prove the defendant's innocence. Why does this show up every time? This is so bad. The state further moves this honorable court to exclude any evidence that defendant has refused to disclose in a timely manner. B. Although exclusion of evidence is an extreme remedy, repeated and intentional violations of reciprocal discovery obligations warrants exclusion of the evidence at trial. Here is my hope, dear folks. Here is my hope. My hope here is that Judge Whittaker has this motion in front of her, looks at the prosecution over at that desk and asks them, do you really want me to take this as you word it? That repeated and intentional violation of discovery obligations warrants exclusion of the evidence at trial. Because now they brought up stuff with what's his face? What's his name again? Bean. About Bean. I mean, really? Do you really want to go back that far and check how much evidence you, as a prosecutor, did not disclose? As Variant says, the state is begging the judge not to allow in evidence is further proof. They don't care about justice. They just want to win. At this point in time, I think it's damage control, desperation. Yeah, something of the sort. Let's continue. The state recognizes that exclusion of evidence is an extreme remedy. Yeah, it is, especially against the defense. Who, do I need to remind you all? Who has rights in a criminal proceeding? There's one party who has constitutional rights in a trial. That's the defendant. Oh, that's a good idea. Nick, do you want to grade her motion and send it back to her? I know what I'm doing after these 3 months. Thank you, Denise. That's a great idea. That is a great idea. The state only asks the court guarantee a fair trial for all parties. One party, and one party alone, in the Constitution and Bill of Rights, have the right to a fair trial. That's the defendant. The state does not. That is such and mandate that defendants adhere to the continuing reciprocal discovery obligations or face exclusion of evidence intentionally withheld in violation of those continuing obligations to disclose. Conclusion. For the reasons stated above, the court should compel each and every defendant in this case to compel with the reciprocal discovery obligations under 17-16-4, and the court should exclude any evidence tendered by the defense that has been intentionally withheld and not disclosed in a timely manner. Respectfully submitted, Adrian Love. Certificate of service to all the defense attorneys. Okay, so this is, she has had this as a header for each page. No, that's not how you do it. The court, the defense attorneys, nor I need to be reminded about this. You wrote it once, that's enough. You wrote it once, that's enough. This is so infuriatingly bad. If you want one of your own, it is in my merch shop, this mug. I will, in the description, I will put it in the description, my merch shop. Yeah, I mean, I'm not even, English isn't even, it's the fourth language I learned. Now I forgot Swedish, German, well, if you count away Norwegian and Danish, but I don't. I can read Danish, I can speak some Norwegian, I can read German. I need to brush up everything about speaking in German, and then I learned English. So, but still, she has a law degree and she does this bad. Yeah, that could be a serious issue if the judge says, too late. Or there's a strong possibility she will just look at this and deny it without a motion, without a hearing, sorry. It's new evidence, so it's wrong. Yeah, because how are the defense attorneys supposed to know what evidence to bring in until the prosecution have interviewed? Is done with the direct examination. Cash, money, cash. Nick, I understand your interpretation more than the hieroglyphs displayed here. Yeah, thank you. Thank you, Gigi. There you have it also, my merch store. I will pin that on the top of the chat. There. I have lots of other stuff on there. Now there are more motions. And let's see if they are equally bad. But first, something I haven't done in a good while. You know what that is? I haven't swooped in a good while. That, my dear friends, is a Norwegian fire-farting dragon. All right, here is the next motion we are going through. The state's response in opposition to defendant Stilwell's motion for reconsideration. Now, reconsideration is the motion the prosecution should have filed, but they didn't. They didn't because they don't want the judge to go back and reconsider Judge Glanville's decisions. Only the ones that was bad for the prosecution. All right, let's go. In introduction. Chief Judge Glanville's ruling that statements made by Young, YSL, member Damikian Garlington to fellow YSL member Kenneth Copeland are admissible co-conspirator statements under OCGA 24, blah, 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 is proper and need not be reconsidered. On September 30th, 2022, defendant Stilwell filed a motion in limine requesting a hearing and objecting to the admission of these co-conspirator statements as inadmissible hearsay. Ultimately, Chief Judge Glanville held the hearing and denied defendant Stilwell's motion. Footnote. State agrees with defendant Stilwell that the record does not reveal any written order encapsulating the court's oral ruling preliminary admitting the statement subject to proper foundation at trial. This is one of these oral orals where he actually never wrote it down. It might be, there's no written order, just an oral order. Only after recusal on July 23rd did defendant Stilwell file this motion to reconsider. There is no legally salient intervening change in statute or jurisprudence warranting reconsideration. Therefore, this court should deny this thinly veiled attempt at the de facto judge shopping, because the court's prior ruling was in accordance with this OCGA. However, if the court is inclined to consider defendant Stilwell's motion, the motion should be denied. I'm not entirely sure. I mean, because they had the motion really early on, but there wasn't an actual written order to deny or anything throughout that almost a year and a half since then. So I'm not sure if my gut tells me that the state will win this one so far. Because it's a bit too late. But then again, Copeland is on the stand now, so it is kind of timely anyway. I'm not sure. Factual background. The defendants are all charged under count 1 with violation of the RICO Act for their participation in the conspiracy of the criminal enterprise of the YSL criminal street gang, which I believe the state they're not even close to proving that they are. That is why the prosecution keep talking about this hybrid gang between a normal street gang and a criminal street gang, which is stupid. It's either or according to law. You're either a normal street gang, which is not illegal, or a criminal street gang, and that is up to the court to decide. The hybrid thing, garbage. As alleged in the indictment, the objectives of the objectives of the YSL include, but are not limited to, preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, blah, 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 blah. This is count 2. Ending, as well as overt act 16 to 20 of count 1 pertain to the January 10th, 2015 gang-related drive-by shooting of Mr. Donovan Thomas Jr. Go back and watch my stream. When we discovered together that the white car or the light-colored car the prosecution alleges contained, whoever it was. Looking at the grill, it's not the same car. It's not the same car at the gas station that is seen on the surveillance camera driving by. It is not the same car. In my opinion, I have to add that. If you disagree, please say it, but I don't mind you telling. I will never, ever, if you have constructive criticism of anything I say or do here, speak out. I don't mind. I welcome it, because I do not learn anything if I only have yay-sayers. Now, I love my yay-sayers, but I also want the nay-sayers. Okay? On June 10th, Mr. Copeland was interviewed at the Atlanta Police Department headquarters by Detective Thorpe, Detective Dennis, and Gang Detective Gaither. The Gaither is, in my opinion, probably the absolute least competent cop I have ever witnessed in any trial. Now, you have people who lie, who cheat, who steal, and do all of that. Miss Gauthier is simply a dumb person who managed to get a job as a cop, got department pinball machine thingy. She ended up in the gang unit. That is not a clever person and completely incompetent. And I will stay. Yeah, she is. I've said this before, but for you who are new here, she left the force after 19 years, not 20, as for getting full pension. Isn't that strange? Why would you leave after almost 19 years? Then she got a job as an investigator at Cook County, the neighboring county, for the district attorney's office. She worked there for a few months, and then she quit. For you know, I do labor law. If somebody is at a position for a few months and then quits because it wasn't for her, that is her employer telling her, either quit or you're fired. That is my opinion, what happened. So that's, yeah, who else was there? During this interview, Mr. Copeland stated that YSL member Garlington informed him that the defendant Stilwell and other co-defendant associates Cobb, McCullen, and Kendrick were responsible. Copeland, that's one step removed, said that Garlington, that's two steps. Garlington informed him that these people, this is 3 times removed hearsay, that somehow Judge Glanville found a reason to admit. Third-hand information is what Judge Glanville thought was proper as evidence in this trial. Third-hand hearsay. I'm having a hard time with second-hand or even first-hand hearsay once in a while. But third-hand, that's the whispering game. Seriously. Also, Copeland discusses other activity that Mr. Garlington shared with him. Again, a lot of hearsay here. For example, discussions about the April shooting of Dwayne Carter's tour bus. That's Lil Wayne, by the way. Mr. Copeland stated on January 10th, sometime shortly after the ending, he met Garlington at a McDonald's parking lot located at Cleveland Avenue. Mr. Copeland saw multiple YSLs arrive at the McDonald's, to include defendants Garlington, McMullen, Williams, Stilwell, Kendricks, and Treadwell. Garlington entered Copeland's car and immediately told him that they just killed Knott. Mr. Copeland, blah, 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 blah. Yeah, we all know that. We heard that. Yeah. So this is just a reiteration of the Some are in the interviews, in the police interviews. Some are in jailhouse calls, and some. Yeah, in my opinion, when you look at the grill of the car at the gas station, which they have clear photo of, and then you watch the drive-by of that light-colored car, it's not the same grill, which means it can't be the same car. Blah, blah, blah. Argument and citation of authority. Statements made in furtherance of the conspiracy are not hearsay. Here's the thing with the Georgia RICO. What is written there? Statements made in furtherance of the conspiracy are not hearsay. Is probably how the Georgia RICO Act is written. Probably. And it's stupid, and it's unconstitutional, in my opinion. It should never be allowed. But welcome to Georgia. Defendant Stilwell's argument ignores numerous facts and controlling legal principles. More significantly, defendant Stilwell fails to recognize that this is a gang and criminal enterprise prosecution. Here is my objection to this part. Just because the charge says it's gang and criminal enterprise, and therefore hearsay should be allowed, or not, statements are not hearsay, I don't care. Hearsay rules are hearsay rule no matter the charge, except in Georgia and a few other states. It's stupid. As such, the underlying conspiracy in question pertains not only to the ending of Mr. Thomas, but more broadly to the activities of the YSL gang. Therefore, the conspiracy in question continues today. YSL continues to exist and operate as a criminal street gang. Then why, Miss Love, Miss Willis, Hilton, and everybody else, if they are a continuous criminal street gang, why aren't their music label on a co-conspirator? They bought the YSL music brand with everything in it. The YSL music recording business is now under other management. Cash money cash. I think they skipped the part where they have to prove RICO first. Yeah, but that's the odd part. It seems like just because they charge under the RICO, there are different sets of rules. And I don't understand how they have statutes for it, but Georgia has statutes for it. Hearsay. Nick, I heard you are a billionaire. Maybe in Kenyan dollars, or I don't know. No, I'm barely a thousandaire. Everything I get from this channel goes back into the channel. And even the trip to the United States, which you guys have so generously contributed to, I still have put in my own money into it. But thank you so much for watching this, giving me some ad revenue, the occasional super chat, and gifted memberships and being members. Thank you so much. I cannot thank you enough for that. You make this, what I do here, possible. And my trip to the United States, where I traveled to the different places where I have covered cases. And by the way, that's a week and a half from now. I fly out on August 7th from Sweden via Denmark, Holland, and then over to the United States. I will land at about 2 p.m. in Houston, I think it's the George Bush Airport. I don't know what it's called. But again, thank you all so much. So in Georgia RICO, any loose affiliation or accusation towards the case is considered fact. Yeah. Then they leave it all up to the jury to decide if what they put forward is enough to prove. Because according to Judge Glanville, when he made this ruling, the prosecution only needs to show a preponderance of the evidence in order to get these things in. Like, it's 50-50, but with a feather. And for me, that is stupid. Yeah, remember, hit the thumbs up while you are here. Help me beat the YouTube algorithm to get me out to more people to see me. And Garlington's statements, better described as party admissions to Mr. Copeland, were in furtherance of that conspiracy. OCGA 24, blah, 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 blah. Admissions shall not be excluded by the hearsay rule. An admission is not only defined as a party's own statement, but it's also defined as a statement made by a fellow co-conspirator during the course of a conspiracy. So, to make that as short as possible, if the prosecution says you are affiliated with a gang, that's enough for us to use anything you ever said to somebody that we can get somebody to testify about. Regardless how much hearsay, regardless how much, they don't even have to prove it's a correct statement, only that the statement should be admissible. We don't know if that statement actually occurred. All we have is Copeland saying it occurred. So we actually don't know if that statement by Garlington actually happened. We have no idea. But the state says that Copeland said it, and therefore it's admissible. That's the vagueness of the Georgia RICO Act. OCGA mandates that hearsay proscriptions do not apply to, quote, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy, including a statement made during the concealment phase of that conspiracy. To admit evidence under the Rule 801, the Georgia Supreme Court has held, the state is required to show by a preponderance of the evidence that a conspiracy existed. The conspiracy included the declarant and the defendant against whom the statement is offered, and the statement was made during the course and in furtherance of the conspiracy. It is like this because the prosecution says it is like this. It's a circular argument approved by the Georgia Supreme Court. Criminal conspiracy. The YSL criminal street gang is the criminal conspiracy in this case, as alleged in count 1, and as the evidence at trial has revealed. No, it hasn't. According to Judge Glanville, it's in preponderance of the evidence. Okay, so he found it 50-50 with a feather, which is stupid. A criminal street, blah, blah, blah. I don't have time. This is... Does she have any... Yeah, let's go. Statements made in furtherance. By the way, just so you know, for you who don't know, you are all part of Mr. Jingle's Viking Thug gang. Both the 11th Circuit and Georgia courts apply a, quote, liberal standard in determining whether a statement is in furtherance of a conspiracy, end quote. A liberal standard means, in plain speak, we want to help the prosecution prove a case as much as possible no matter what other rules we break. That is the meaning of that. To be admissible under this code section, a co-conspirator admission, quote, need not be necessary to complete the conspiracy, but must only further the interest of the conspiracy in some way. I mean, the vagueness in the language here is infuriating. And this is not because of love of Hilton or even Judge Glanville. It is because the lawmakers in Georgia wants it to be this way. Yar is here. Statements between co-conspirators which provide reassurance serve to maintain trust and cohesiveness among them, or inform each other of the current status of the conspiracy, further the ends of the conspiracy. Here's my issue. This statement is only spoken by Woody. We do not know if Garland actually said it, unless he's in a recording, which we don't know yet. Even boasting or bragging is in furtherance of a conspiracy if the statements, quote, are directed at obtaining the confidence or allaying the suspicious of co-conspirators. Boasting or bragging or lying, maybe. A statement can also be in furtherance of a conspiracy when it is, quote, necessary to keep a co-conspirator abreast of the conspiracy's current status. Furthermore, narratives of past events, however, are admissible under Rule 801 if they serve some present purpose in the conspiracy. I mean, the vagueness in this language should not be constitutional. I mean, for over here at least, we have a rule that in order for a law to pass the legislators, you should be able to read it to a 15-year-old, and that 15-year-old understands it after the first reading. Now, our politicians, they don't follow it, but we try to follow it and hold the politicians accountable when they go haywire. In Georgia, this is on the lawmakers, completely on the lawmakers. The lawmakers could make this disappear after the election. But I don't believe any of the parties in Georgia are interested in good laws in this. Statements are admissible where the state can meet the requirements of Rule 801. Any co-conspirator statements made in furtherance of the YSL are admissible as non-hearsay statements. Notably, the state need not prove the existence of this conspiracy prior to the admission of the statements at trial. Chief Judge Glanville has stated, and the state has introduced evidence at trial that has proven to a preponderance that YSL is and was on January 10th, 2015, a criminal street gang. It is this stupid. Cash Money Cass says, so for example, by having an improper ex parte, Judge Glanville is a co-conspirator to the prosecution's dealings because it, quote, furthered the interest of the conspiracy, quote, to derail the defense. Yeah. Another example is Fonnie Willis conspired with Nathan Wade to embezzle money from Georgia taxpayers. 2 or more people is enough to have a criminal conspiracy or a criminal enterprise in the state of Georgia. Just saying. Application and analysis. Currently, the state has already provided evidence and testimony to prove by a preponderance of the evidence that YSL is a criminal street gang. And both Kenneth Copeland and Demikion Garlington were members of said conspiracy on January 10th, 2015. Here is my issue with this. In my opinion, the only people who can decide if there is a preponderance of the evidence is a jury. Sadly, there seems to be a grand jury in place here. And most of you already know this, but you can indict a ham sandwich in a grand jury. Rarely does a grand jury say, no, we're not doing this. The YSL gang is an ongoing enterprise and conspiracy, and now they keep repeating. Prosecutor loves repeating herself over and over again because that makes her motions longer and seem more important, unless somebody like me shows up. For you who don't know, I spent 3 years in the European Parliament as a documents analyst. I literally read tens and thousands of garbage papers. This is a garbage motion. I don't think Adrian Love has the mental capacity to write a good motion. I honestly don't think. The only reason here why this has bearing is because the laws and statutes she relies on are equally bad as her. Do I want to... Yeah, this is just Inglewood family bloods, blah, blah, blah. Alternatively, the evidence is also admissible as a declaration against interest. Mr. Garlington's statements to Mr. Copeland is also admissible as a declaration against interest pursuant to these rules. The code permits the admission of a hearsay statement, which a reasonable person in the declarant's position would have made only if the person believed it to be true, because, when made, it was so contrary to the declarant's proprietary or pecuniary interest, or had so great a tendency to invalidate a claim by the declarant against another, or to expose the declarant to civil or criminal liability, ... and supported by corroborating circumstances that clearly indicate the trustworthiness of the statement if it is offered in a criminal case as a statement that tends to expose the declarant to criminal liability. This is word vomit. Apparently, this is some judge decided, I want to write it this way. I don't know who it is, but whoever it is, Jesus Christ, don't stop being a judge. This is a very, very, very wordy way to say, if a reasonable person believes it, then it comes in. What's a reasonable person? Well, I have no idea. Many people with high intelligence are not reasonable at all. Many people with low intelligence are highly reasonable, and every variation in between. That reasonable person standard, in my opinion, should only apply when it comes to free speech decisions. What would a reasonable person deem offensive? And there are so many now that I'm not even sure of that anymore, because there are lots of easily offended people out there. Lots of them. Or there are very few, but extremely loud. I don't know. To be admissible under Rule 804, a statement must satisfy 3 requirements. The declarant must be unavailable. That would be Mr. Garlington. Okay, why is Mr. Garlington unavailable? Garlington, YSL. Why isn't he available? Let's see here. Garlington. Are these people who are severed? Yeah, it seems like Mr. Garlington is severed from this case, but the only reason the Garlington is unavailable is because the prosecution don't want to call him. I don't know. The statement so far tends to subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true. And the statement is corroborated by circumstances clearly indicated its trustworthiness. Yeah, it's so vague. I hate vagueness. I want laws and statutes to be clear-cut, as clear as possible. The United States Supreme Court has previously explained the logic behind this rule. Quote, Rule 804 is founded on the common sense notion that reasonable people, even reasonable people who are not especially honest, tend to not make self-inculpatory statements unless they believe them to be true. Further, quote, courts have held that the mere fact that the recipient of the information was a confidant of the declarant does not rule out admissibility of a statement against interest. Is this the United Supreme Court? I think this is taken way out of context. Yeah. Is my blood sugar a little low? I don't think so. I don't think that. Garlington's statement was a declaration against interest. Mr. Garlington's statement to Mr. Copeland admitting his knowledge about the ending of the crimes and its perpetrators. We don't know if he actually said this. Do we? I have yet to hear anything about any recording of Mr. Garlington saying anything of this. All the prosecution have is Copeland, Woody, saying Garlington said it. First, Mr. Garlington is charged in this case with Stilwell. Assuming Garlington does not testify, he is unavailable for purposes of Rule 804. Well, have they tried? Why is this admitted before they know if Garlington testifies or not? As to the second prong of the analysis, Garlington's statement is self-inculpatory. Garlington has significant information about the gang-motivated crime, and Garlington is a member of the same criminal conspiracy as those he named. How do we know he actually named them? And by the way, when we talk about people who are involved, where's Mondo? Fannie Willis, where's Mondo? Why isn't YSL Mondo anywhere seen in this indictment? Well, we already know that. Why? Because Fannie Willis represented Mondo in a case years ago. It is my opinion and my theory that Fannie Willis got every base fact about YSL in order to do the prosecution from Mondo. In my opinion, the only way Fannie Willis could get this amount of information was if Mondo told her as her client. In my opinion, Fannie Willis should be investigated thoroughly for breaching attorney-client privilege. Well, I haven't covered this garbage trial for over 2 years. I've been covering this case for 14 months, 15, something of the sort. Therefore, given the context of Garlington's relationship with Stilwell and the other YSL associates who blah, 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 Garlington had no reason to lie. We don't even know if he said it. We don't actually know if Garlington did the statement. All we have is Copeland saying he said it. Finally, as to the third required prong of the analysis, court has found that self-inculpatory statements are sufficient, corroborated where the evidence presented at trial supports the veracity of the out-of-court statement, and where the declarant makes the statement to someone with whom he shares a close relationship. Mr. Copeland and Garlington are members of YSL with shared affiliations, shared a relationship for a number of years. Mr. Copeland testified that out of all the YSL members, he is the closest to Garlington and Stillwell. These conversations were not to law enforcement, but amongst close members and friends. Are there any recordings of this? Are there anything but Copeland's saying so? Anything? I don't think so. Therefore, this statement is not only admissible as co-conspirator admission, but it is also admissible as a statement against interest. This court should thus deny Stillwell's motion to exclude this statement and hold that this statement, as any other related statements, are admissible upon the state establishing the proper foundation at trial. Mr. Garlington's statements to Mr. Copeland was correctly held to be admissible in this case by Chief Judge Glanville and should not be reconsidered. Did I miss anything here? Because I have yet to hear Garlington claiming he said these words. To my knowledge, the only person claiming that Garlington told this to Woody is Woody. Contrary to Stillwell's claims, the Georgia Evidence Code has blah, 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 blah. Adrian Love, again. She, except for one reply by Fanny Willis, they are all written by Love. And you see here, where are Hilton? Where's Hilton? Why hasn't she signed it? Where are the other prosecutors in the prosecution's team? Why is it only Adrian Love here? All right. Certificate of service. Now we have one last that I know of. I actually haven't checked yet if there are anyone else. Oh, let me check first. Let me check here. Dun, dun, dun. Dun, dun, dun. Come on. No, only 3 filings, both according to Thug Daily and the other guy with the Polish name, which I don't remember at the moment. Okay, it seems like these the reply, I mean, this means there's only a combined 7. But the 4 state responses were to one and the same. Hey, Nana Misty, hello. Thank you so much for $2. Good morning, Nick, Mods, and Thugs. Good morning, Nana Misty. So this is the last one from the state. What about all the others? This is weird. But if only Miss Love wrote it, yeah, then there probably wasn't enough time. Which means there are some motions from the defense that goes to the hearings unresponded to. That will be interesting. That will be really, really interesting. Do I think defense will call Garlington? I don't know. I honestly don't know. But here is the last one. Let's continue. Let's have a swoop. Let's have a swoop. Let's have a swoop. Where is my swoop there? The Norwegian fire-fighting dragon swoop. All right. Response in opposition to defendant Nichols' motion for mistrial and severance. This is the one I read on Friday by Bruce Harvey, Attorney Bruce Harvey. Attorney Bruce Harvey, his writing is excellent. Excellent. The state of Georgia hereby moves this honorable court to deny defendant Nichols' motions for mistrial and response in opposition to defendant's objection to trial judge substitution. In support of this motion, the state shows this honorable court as follows. Oh, she has an introduction. A mid-trial substitution of a judge do not violate the 6th or 14th Amendment rights to trial by jury. In my opinion, if it was a week-long trial, maybe. We are 8 months in. Folks, we are 8 months in to this trial. That's a serious difference. 85 or 84 witnesses in. We're in the middle of the prosecution's case in chief after 100 days of trial. In paragraph 1, defendant Nichols asserts the mid-trial substitution of the trial judge violates his 6th and 14th Amendment rights. The mid-trial substitution of a judge does not violate the 6th Amendment or 14th Amendment rights. This claim was made in McIntyre v. State, and the Supreme Court of Georgia assumed for purposes of this appeal only that these rights are implicated by the mid-trial substitution of judges. This is important for purposes of this appeal only. Now, this means that the Georgia Supreme Court said this is an exception. We are only applying this to this trial and nobody else. Now, since it's a Georgia Supreme Court decision, prosecutors will still try to use it in other cases, and they probably have already. Nana missed it. Thank you for your $5 super chat. They are all so crooked they make a slinky look straight. I don't understand how this is not misconduct. Neither do I. Neither do I. And ultimately rejected that claim. However, when it did so, the court specifically referenced People v. Espinoza, in which the Supreme Court of California held that a mid-trial substitution of judges does not violate those rights. People v. Espinoza. Let's see. How long was that trial? That is, the original information had charged Espinoza with assault. So it was an assault trial. Let's see here. I am here reading. After a jury trial, Espinosa was found guilty of assault with a deadly weapon. Is this the correct one? I have to check again. Oh no, this was a death penalty case. All right, so not as an assault case. This is the one. Death penalty. Exclusion of evidence about a proposed polygraph test. Yeah, polygraph test. I'm so happy those are completely excluded. Animosity between the prosecutor and the defense counsel. Yeah. Jury's comment on the defense witness. Instructional error. Where is that? Ruling, here it is. Ruling on the automatic application to modify the verdict by judge who did not hear the entire guilt phase trial. So the guilt phase of defendant's trial commenced before Judge Kenneth Ferguson, who conducted the proceedings until, during the presentation of the defense, he became too ill to continue with the trial. The presiding judge of the San Quentin County Superior Court then assigned Judge Peter Sayers to substitute for Judge Ferguson pursuant to section blah, 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 blah. Which means this case does not apply. Because this here was in the... wait a minute. I must... Defendant moved for mistrial, asserting that a mistrial substitution violated his Sixth Amendment right to jury trial by denying him the same judge throughout the entire trial. Judge Sayers denied the motion and, after reviewing the transcript of the proceeding, presided over the remainder of the guilt phase and the entire penalty phase of the trial. Okay, so here we have it. Reviewing the transcript. So before that trial commenced, Judge Sayers reviewed the entire transcript. So it's very, very different. Because this, Judge Whittaker, how much I enjoy that she is here, already stated that she does not intend to go back. She just wants to move forward, which makes this completely different, in my opinion. Normal circumstances are, let's see, do we have the timing here? Mid-trial. Dun, dun, dun. Because Judge Sayers replaced Judge Ferguson mid-trial, Judge Sayers did not hear all of the guilt phase testimony, specifically the testimony of Jose Uranga that he had overheard an argument between defendants and an unidentified man, implicated defendant as the... That sounds weak, by the way. Because Judge Sayers did not personally hear this testimony and thus could not possibly evaluate Uranga's credibility, defendant asserts, well, it's not the judge who asserts credibility, that's the jury. That's the problem. Bam, bam, bam. Consequently, it doesn't really say how long into the trial this happened. Yeah, it's hard for me to say, but this definitely wasn't a 6-month trial. Let's just say that. So the circumstances are completely different, in my opinion. Not to mention that he was removed for misconduct. The judge in that case was just sick. Exactly. Let's see, reference people in which the Supreme Court of California held that a mid-trial substitution of judges does not violate these rights. Now, this is Supreme Court of California. Not one judge in Georgia need to follow what a Supreme Court in another state says. Concerns with directed verdict motions are unfounded. In paragraph 2, defendant Nichols asserts the mid-trial substitution is inappropriate because he claims it will affect his ability to request a directed verdict at the conclusion of the state's case in chief. This concern is unfounded, as a directed verdict of acquittal is only available if the evidence is insufficient as a matter of law. For you who know, one of the trials I covered had a directed verdict. This is not up to the prosecution. The prosecution has absolutely zero to do with how the judge rules in a motion for a directed verdict. They have a right to argue against it. But they cannot say as a fact, as Ms. Love tries to assert here. They cannot and shouldn't even be allowed to argue this. At least not this specific. This is something they can argue when they get there. But here, they have to argue how the judge. Yeah, this is not a correct argument. This is not a correct argument. C. Issues with familiarity. In paragraphs 3, 4, and 6, defendant Nichols asserts the court advised the parties that she was unfamiliar with the previous trial proceedings, and this would affect the court's ability to rule on motions and objections. In paragraph 5, defendant Nichols asserts the court's level of familiarity violates his due process rights. Defendant Nichols' claims turn upon this court's familiarity with the case. Among those jurisdictions which have statutes regarding the mid-trial substitution of the trial judge, some require the new judge to certify their familiarity with the record. Federal Crim Pro 25. Quote, the judge completing the trial certifies familiarity with the trial record. Massachusetts, any other judge that the court or properly assigned to that court upon certifying in writing that he has familiarized himself with the record of the trial may proceed with and finish the trial. Some jurisdictions with such statutes do not impose such a requirement. People with Cohen, California, imposes no requirement that a substitute judge certify his or her familiarity with the record, and thus authorities from other jurisdictions that do are inapplicable. So these few parts here is what I said earlier. Georgia doesn't have to follow what happens in California or Massachusetts or Washington or anywhere. They don't have to. Georgia does not have such statute. Which one? Again, this is so horribly bad by Adrian Love. She gives examples of jurisdictions that has requirements, and then she gives example of jurisdiction that doesn't have these. And what does she follow up with? Georgia does not have such statute. Which one of them? Which one of them? Jesus. This is so bad. How the flaming F does she have a bar card? Georgia's primary case is McIntyre v. State, while one concurring justice opined that she, quote, would have the replaced judge scrupulously review the prior proceedings and state on the record his or her familiarity therewith, so as to establish that the replacement judge is fully prepared to render informed rulings on any matters that might arise to instruct the jury thoroughly. There is no authority requiring that within Georgia law. The majority opinion itself in McIntyre leaves the matter to harmless error review. Yeah, welcome to Georgia. Regarding the Constitution, I can bet that McIntyre v. State. Let's see what this is. McIntyre v. State, 1995. Okay, that's a murder trial. Dun, dun, dun. Okay, listen here. The murder was committed. Now, let me bring it on. There. The murder was committed on January 17th, 1988. McIntyre was indicted on March 1st, 1988. The guilty verdict was returned on June 10th, 1988. So everything here happened within the span of less than 6 months, from the crime to the conviction. He was indicted on March 1st. Indicted doesn't mean the trial started then. So this was, at most, in my opinion, let's see here. Why doesn't it say so? When does the indicted March 1st? Guilty verdict was returned June 10th. So somewhere in that 3 months. But I can bet good money that trial was maybe 2 weeks long. Maybe. Is this a satanic panic? Oh. When evidence is construed strongly in favor of the state and against McIntyre, the jury was authorized to find the following. McIntyre became a member of a satanic group, of which Terry Chapman was the leader. I need to find that trial. Because this late 80s, early 90s was in the height of the satanic panic. Huh. Where is it? During the trial, Judge Robert Noland initially presided but had to leave during the state's presentation of evidence in order to attend the funeral of his infant grandson. Judge Robert James replaced Judge Noland over McIntyre's objection. McIntyre contends that the substitution of judges, blah, 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 blah. Harmless error analysis. Although Hood held that the state must rebut a presumption of prejudice or demonstrate beyond a reasonable doubt that the error was harmless, it also recognized, quote, that a number of courts have held to the contrary and have required that the defendant demonstrate actual prejudice in order to obtain a new trial. Similarly, in Georgia, the temporary absence of a trial judge without suspension of the trial is not a basis for reversal unless the complaining party shows prejudice resulting from the absence. McIntyre has not shown that he was harmed by the substitution, and therefore, under the circumstances of this case, the procedure followed in the trial court does not require reversal of the judgment of conviction. Okay. I need to check. I have a lot to do after this. Nana Misty says, again, not from misconduct, but a death of a grandchild. These are different. Yeah. Let's go back to the motion here. While one concurring justice opined that she would... That's the same... Okay. The majority opinion itself in McIntyre is the matter to harmless error. Regarding the constitutional aspect of defendant Nichols' claims, the Supreme Courts of other states which have considered this issue have determined that the mid-trial substitution of a judge does not violate the defendant's constitutional due process rights. Still, how many of those trials were the trial after 6 months? The prosecution wasn't even halfway through their case in chief. People with Thompson in New York, we find nothing in the requirements of due process that indicates that a mid-trial substitution of a judge rises to the level of a per se constitutional violation. So, more or less, there is actually nothing in Georgia. If defendant Nichols' argument about personal or direct observations were correct, then no mid-trial replacement could ever be permitted. Maybe it shouldn't. Maybe it should be a mistrial and force the prosecution to start over. Maybe, just maybe, if a trial judge hears half the trial and then pops off, it should be an automatic mistrial and start over. Maybe. Given how well established it is that one judge can replace another judge during a trial, especially when circumstances require it, these arguments are unfounded. Yeah, but you have to look at what circumstances they are. The state see no reason to believe that this very capable court is unable to rule appropriately on motions or objections moving forward. Indeed, given how easily available recordings of these trial proceedings are, the defendants in this case are better off in some respects than defendants in other substitution cases would be, as the parties can and have cited this part. The defense, any one of them, should copy. Well, if this very capable court are this able to rule appropriately on motion or objections moving forward, why do you object this? Why do you object to Judge Whittaker taking a new look on old rulings? Why? Here you argue that she is fully capable of doing it. So why do you argue against it in another motion? Blah, blah, blah. Further, even though Georgia does not have a requirement that the court certify familiarity with the record, the state offers to do whatever it is within its power to do to assist the court in gaining appropriate familiarity. Oh, I'm sure you really, really want to be in judges' chambers to instruct Judge Whittaker on how she should read the transcript. How about you go screw yourself? How about you stay way away from judges' chambers? D. The temporary recess of the trial is not a basis for a mistrial. Defendant Nichols moves for a mistrial given the month-long recess in the proceedings. Defendant Nichols cites no law in support of that claim. Indeed, a month-long recess, though unusual, is not unprecedented. We are going into a 2-month recess. See State v. Campbell. Month-long recess occurred during jury deliberations when a juror was in a car accident, which means not the same. It's not the same. It's not even close to the same. State v. Antoine. Defense counsel's illness prompted 2-month recess. Illness, not misconduct from the judge. Corona v. State, unpublished, then I don't care. The court should again deny the request for severance. In paragraph 8, defendant Nichols again moves for severance based on alleged spillover. This court should again deny that motion. It's well established in Georgia, quote, that, quote, where evidence of one crime would be admissible in the trial of the other crime, it cannot be said that that trial court abuses its discretion in denying a motion for severance. Then why are 12 other severed from this case? Why is Mondo completely severed from this case? Although this rule is most often recited in cases reviewing the lack of severance as to one defendant's multiple offenses, it has applied in between co-defendants. Here, defendant Nichols and his co-defendants are each charged with a violation of the Georgia RICO Act. So are the other 12, in which the state alleges they engaged in conspiracy. Defendant Nichols' separate actions and those of his co-defendants are alleged in the indictment as overt acts of that conspiracy. I believe Mr. Nichols is mentioned twice in this entire indictment. These are not just separate but related crimes, but the same crime, the RICO conspiracy charge. Then why are 12 other defendants severed from this case? Why are not all 18 in there? A federal district court has provided a cogent summary of how the issue of severance of defendants works in a conspiracy case. I don't care. I really don't. Because if 12 people can be severed, then this argument up here is invalid. If they have been severed, then the same argument they place here could be placed against the other 12. And those were severed. In other words, if that argument holds up, then all of them should be there. All 18 of them. Here, defendant Nichols and his co-defendants' acts are evidence of the RICO conspiracy, blah, 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 blah. There are no basis for severance in this case, and this honorable court should deny defendant Nichols' motion. Conclusion: for the reasons stated above, the state respectfully moves this court to deny defendant Nichols' motion for a mistrial. And again, only Adrian Love. Where is the other prosecutors? Why no other signees on this certificate of blah, blah, blah? I can't wait until tomorrow. I really can't wait until tomorrow comes, folks. Because tomorrow, when the hearing starts live, I've already told the office that I'm going home at 1 p.m. tomorrow, my time, which is 7 a.m. your time. So I will be ready, up and going once the hearing starts. And remember, Judge Whitaker, when she says 8:45, she means 8:45. There's no way around that. Question: if the evidence is one for all, would that mean a mistrial, that evidence is no longer usable if it's double jeopardy attached? Only for the 6. Say for some, if the Judge Whitaker finds that it is enough for a mistrial with prejudice, then for these 6 defendants, it's over. For the other 12, that's still ongoing. Citing Cox v. versus Illinois, blind people shouldn't be held accountable for regular seeing crimes. Oh. All right. That is, I think, all I have for you guys today. Oh, this has been interesting. This has been really, really interesting. Really, really interesting. Now, I can't wait until tomorrow. I really, really can't. Now, for you who don't know, there's a Disney case going on. So I will be sending you all over to Kurt at Uncivil Law. But first, thank you for being here. Thank you for allowing me to do this. Thank you for your support to me. And this week will be interesting. Next week, I will do Monday, Tuesday. But Wednesday is a travel day for me. Then it's Thursday, Friday. I will be attending the Matsuri convention. I will try to do recaps of what happens in court, but no streams. But I will try to cover as much as possible, but I will also give you travel videos. Where I am, what I do. I need to visit in Houston. I need to visit a hat shop because I want a proper cowboy hat. I need to visit Walmart and all the other stuff that the United States offer, all the things. And I will record and I will post videos about it both here and on my channel that is more devoted. Because if I post too much travel stuff here, then YouTube will destroy my algorithm. But yeah, let's see here. Yeah, that's it for me for today. Thank you again. And hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.
Storming through the halls of justice, a Viking lawyer with a scornful grin, mocking the prosecutor fighting for stealing from the